Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, huge thanks to everyone who got up early this morning and hung out with Washington Gun Law as we waited for the Supreme Court orders list to come in, only to find out that both the Snope and Ocean State case petitions have been denied. Now, I understand that a lot of you are completely freaking out and are very, very furious over this. And this would be the time where normally Washington Gun Law would come in and be like, okay, everyone, take a deep breath. We're going to go through this and we're going to chill everyone out. I don't know if I'm going to be able to chill anyone out here today, okay? This is a bad day for a lot of bad reasons, and I think there's a lot of bad mojo coming our way because of that. So today, let's break it all down and let's spend a few minutes and let's talk about a brutal day at the Supreme Court means more brutal days ahead. Okay, America, listen, we're going to be talking about the bloodbath that took place at the Supreme Court this morning. Thanks again to everyone who's been tuning in to WGLAM for the last several weeks as we got up super early to go over that Supreme Court orders list with you. Today, when the orders list came up, we did not see it as certiorari granted, so we did a word search, and unfortunately, we found Snope and we found Ocean State. What we're going to do is we're going to talk about both cases. Ocean State, for those of you who have seen orders lists before, you know that they are incredibly simplistic. This is what they look like. And all we got as far as information on Ocean State Tactical is the petition for writ of certiorari is denied. Justice Thomas, Justice Alito, and Justice Gorsuch would grant the petition for a writ of certiorari. What that means is those three justices wanted this case accepted. What it also means is that Justice Kavanaaugh, Justice Coney Barrett, and Chief Justice Roberts did not want these cases accepted. So, hey, we got ourselves a 6-3 conservative majority. Do we? All right. Now, when it gets to Snope, we got a lot more information. We got a very strongly worded dissenting opinion from Justice Thomas, which we will spend some time with today, obviously. And then we got this feckless apology letter, if you would, from Justice Kavanagh. And I got to be honest with you, Justice Kavanagh, had he decided that it was time to accept review in these cases, would have been the deciding vote. Instead, he decides that it's not time to take them, but he then wants to write a statement of Justice Kavanagh respecting the denial of certiorari. Not a dissent, just a, hey, let me apologize for shooting it down and let me make you some promises that I will not keep. This is what Justice Kavanagh had to say in part. Under this court's Second Amendment precedents, moreover, it can be analytically difficult to distinguish the AR-15s at issue here from the handguns at issue in Heller. Huh? How are these any different? Can someone help me explain? Because we are talking about the common use test. And the common use test says that the American people basically get to decide what's appropriate for self-defense. And that we cannot ban arms unless they are both dangerous and unusual. So I'm not certain how Justice Kavanagh gets confused by that. But then, to just rub a little salt into the wounds here, I want to go through how he concludes his statement. In short, under this court's precedents, the Fourth Circuit's decision is questionable. Questionable. Although the court today denies certiorari, a denial of certiorari does not mean that the court agrees with a lower court decision or that the issue is not worthy of review. No, actually, Justice Kavanagh, that's exactly what it means to the American people. That's exactly what it means to lawful and responsible gun-owning Americans nationwide. And it doesn't matter what you decide to put in your statement on denial. We're just not buying it. It is a massive slap in the face. Justice Kavanagh also states, the AR-15 issue was recently being decided by the First Circuit and is currently being considered by several other court of appeals. So he wants all of these decisions, I guess, to percolate. But here's the problem. If you take a look at the citations of all the cases he's talking about, ask yourself this, America, where do you think these cases are going to come down? Because the cases he cites to are from California, Connecticut, California, New Jersey, California, Illinois, California. And then has the audacity to conclude his statement with, opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for certiorari will likely be before this court shortly, and in my view, this court should and presumably will address the AR-15 issue soon in the next term or two. Okay, so that is literally a Supreme Court justice telling you, yeah, we're probably going to get around to it after we let many other courts develop bad law. And it shocks me how a president who wants to deport illegal immigrants or wants to, cut wasteful and fraudulent government spending can get addressed by the Supreme Court literally 2 days later. But this issue, which has been kicking around now the better part of 2 decades, the Supreme Court's not quite ready to get around to it. Then we have to get to Justice Thomas, okay? Because you can imagine where Justice Thomas came down on it. And yes, a very strongly worded, although not particularly unique, 8-page dissenting opinion. Justice Thomas, who, as you can understand, was more than willing to accept petition of this case, states the following. The Fourth Circuit held that it is, reasoning that AR-15s are not arms protected by the Second Amendment. I would grant certiorari to review this surprising conclusion. Yeah, because you got to remember that the decision here that was being appealed is the appellate court had said that the AR-15, the semi-automatic rifle, is in fact not protected at all by the Second Amendment. It is not a bearable arm protected by the Second Amendment. That's the ruling that's being upheld today by the court's denial of the petition. As Justice Thomas put it, it is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework. To start, AR-15s are clearly arms under the Second Amendment's plain text. And because they are arms under the Second Amendment text, what we end up with is this absolutely unlawful and unconstitutional burden shifting that took place in the Court of Appeals. Because once we establish, and it's very easy to establish that it's a bearable arms, the burden immediately shifts to the government, or at least is supposed to shift to the government for them to establish its legitimacy through historical analogs. As Justice Thomas put it, because AR-15s are arms, the burden shifts to Maryland to show that banning AR-15s is consistent with this nation's historical tradition of firearm regulation. But I'm not aware of any historical regulation that could serve as a proper analog to Maryland's ban. And listen, we were all excited in the summer of 2022 because we finally had a case, so we thought, called Bruin that had a lot of teeth to it. Well, I got news for you. That case has no bite at all, and neither does Heller anymore. And as Justice Thomas pointed out, a prohibition of an entire class of arms that is overwhelmingly chosen by American society for these lawful purposes falls outside the government's power. And understand, the burden of proof that the appellate court required here will now place every other similar petitioner in an absolute impossible situation where they will never be able to establish what the appellate court believes is the threshold proof in order to have a Second Amendment claim, as Justice Thomas points out. This reasoning is dubious at least twice over. The Fourth Circuit placed too high a burden on the challengers to show that the Second Amendment presumptively protected their conduct, and its determination that AR-15s are dangerous and unusual does not withstand scrutiny. And listen, it is very important that we understand what the burdens of proof are moving forward on these challenges. But right now, they're all over the board. The Supreme Court had a chance to clean it all up. They are not interested, as Justice Thomas points out. A challenger need only show that the plain text of the Second Amendment covers his conduct. But that is not what the Fourth Circuit ruled. No. The Fourth Circuit came up with an entirely different test, one that the petitioners would never, ever be able to meet. And that leads Justice Thomas to state, our precedents make plain the Fourth Circuit's error. Under the plain text of the Second Amendment, the challenger's only burden is to show that AR-15s are bearable arms, that is, weapons of offense. And so what this also means, America, is that this incredibly dangerous balancing test, which has been injected back into the equation now, where the courts get to determine what they believe is appropriate for self-defense, because after all, it's not in common use, it's in common use for self-defense, right? And that leads Justice Thomas to this obvious statement of law. Our Constitution allows the American people, not the government, to decide which weapons are useful for self-defense. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. Well, I think that many Americans would agree that there absolutely is no constitutional guarantee offered to them through the Second Amendment as it sits today with this particular Supreme Court. And then finally, Justice Thomas points out the obvious here. I would not wait to decide whether the government can ban the most popular rifle in America. That question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade. Okay, so what does this mean? Well, what it means is that for all of us that are living behind iron curtains already with assault weapon bans and magazine bans, they're not going away anytime soon. I was hopeful that by perhaps next summer, a year from now, we would actually have resolution on this issue. We're not going to have resolution on this issue. Now, I know that many of you are thinking, well, they're just waiting for a better case. They're waiting for the Duncan and the Miller cases to come out of California. But I would ask you this. They already had Duncan and Miller sitting on the doorstep, and what did they do? They GVR'd it. Why? Because they didn't want any part of it. And even though they thought that Bruin was going to solve all of this, it has not solved any of it. And the Supreme Court is unwilling to stick up for its own precedent. And you arguably have a Chief Justice that has undermined it with language in Rahimi. What it also means is that all of these states that have been kicking around ideas of civilian disarmament are going to be completely emboldened. So if you're in a state that's been fighting assault weapon bans for the last few years, you better buckle up, because your next legislative session, they are coming full blast for your firearms and they are coming full blast for your magazines. And candidly, right now, I don't know if there is a legal system in place that is actually going to prevent them from doing that. Yeah, so we'll go ahead and wait for the Ninth Circuit to finally get around to Duncan and Miller sometime in 2028, 2029. I will tell you a case that you should keep your eyes on as far as magazine bans goes, a case that's completely finished out of the Washington State Supreme Court, State of Washington versus Gators Customs Guns. I've already taken a look at the draft on the petition to the United States Supreme Court on that. That case could certainly move into pole position for magazine bans, but what does that really mean? What does that really mean? Because these cases were ripe for the taking. These cases were exactly what the United States Supreme Court had said they always wanted. These cases had perfect records, and we were ready to finally resolve this issue once and for all. But as it turns out, even though we supposedly have a 6-justice conservative majority, they really don't want to resolve this case now, do they? Okay, listen, we're going to go ahead and link up the orders list down below so you guys can geek out on it for yourself. You guys know the drill. 3 fingers of bourbon, breathing exercises, or barf bag. You're going to need one of them. If you got any questions about this or what's left of our Second Amendment rights, which I don't know how much that is left anymore, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video, you click on that link right there and you tell us all about it. And if you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, America, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.